Hello, everyone, and welcome to our second virtual NMLS Ombudsman meeting. I'm your NMLS Ombudsman, Jim Payne, and I appreciate you being here. It's really hard to believe that it's been an entire year since life changed for us almost entirely. We've had to deal with so many challenges we'd never thought of, and I hope you have all remained healthy and safe, and I look forward to my first in-person Ombudsman meeting sometime in the near future. The Ombudsman is a resource for NMLS users with the goal of assisting in the resolution of policy and operational issues. The objective of the Ombudsman and this meeting is to foster a constructive dialogue between the users of NMLS and state regulators to mutually work towards the goal of modern and efficient financial services regulation. And now some issues brought to the Ombudsman can be resolved rather quickly, and others take months or even years to resolve. In addition to topics raised at the meeting, during the 2020 NMLS conference, the Ombudsman received 214 emails between September 1st of 2020 and March 31st of this year. And that represents a 50% increase compared to the previous 7-month period. The emails are reviewed by the Ombudsman and either responding directly or referring questions to SRR staff. Many of the questions are answered with help from the NMLS call center, various departments within CSBS, state regulators, and or even the CFPB. Over the last 7 months, the Ombudsman received an average of about 31 emails a month. Of those emails received, the top 5 categories in order of frequency were entitlement issues, which were password resets and account access, how to file consumer complaints, testing questions related to the SAFE MLO test, the annual renewal period, and 5th was general questions about state licensing requirements. Also, last month marks the first anniversary of the launch of the state examination system. It's the only nationwide system connecting agencies and companies in the exam process. And so congrats to the SES team on a fantastic work product and a very successful product. Now, before we begin, I want to pay a tribute to an important person in the development of NMLS. And to do that, I'd like to invite John Ryan from CSBS, Charles Cooper from Texas Department of Banking, and Bill Matthews from CSBS to the stage. So John, Charles, and Bill, if you'd please come on stage by sharing your audio and video.
Hi, Jim, and thank you. Hopefully you all can hear me.
Yes, we can.
All right, terrific. Well, it is my pleasure to take a moment as we begin the NMLS Ombudsman meeting to honor an individual, Bill Matthews, who will be retiring in June. Bill has played, crucial understates the role that Bill has played in the creation of the NMLS and the system that it is today. Bill came on board CSBS in September 2005, 16 years ago. And I'd like to provide a little bit of the context, the environment when Bill joined and what he was stepping into and what we knew and we didn't know at that time. States had begun to see the need for greater coordination in mortgage regulation, regulation of the origination and lending business. There was a time where we were seeing a real uptick in abusive lending practices, fraud, and leading into what became known as the Great Financial Crisis. So at that time, we didn't know this was going to be a global crisis, but we did see a crisis in many of our communities. And there was a need to share information, coordinate our supervision, and enforcement actions. So commissioners, CSBS being their national Washington-based organization, started talking about solutions to this problem and the possibility of using CSBS as a mechanism to facilitate a platform for licensing and supervision. But we had really no organizational support internally. We had the support of our members, or the idea of our members. We didn't even fully have the support yet. So not only was this a huge undertaking of CSBS, which at the time had a staff of 26, but we didn't have the experience at CSBS, and we had to look outside. We had to bring in someone with, we thought, the ability to, we knew the ability to develop large system implementation. And we thought private sector experience in that kind of development would be helpful. We were really fortunate, and I would say beyond fortunate. It was an alignment that we will forever be grateful for, that we had met Bill as we were looking to service providers that we might work with to develop a system like NMLS, didn't even have a name yet. And we came across Bill Matthews, who was running a mortgage industry fraud database called Mary. And we approached him to come on board. So not only did Bill come on board understanding that success wasn't guaranteed, I think he actually thrived knowing that success wasn't guaranteed. He loved to challenge, he loved to solve problems. We had an idea, as I said, no internal staff expertise. Bill was employee number one. We didn't have a contractor yet. We didn't have that much money, but we did have a deep commitment from leaders within the state system. Bill quickly committed to finding that contractor, managing a state agency working group, hiring staff, and the myriad of other activities commensurate with building and launching a major system. And from that day forward, as we often joke, the workload has never slowed. Through launching the system, building out the mandates that came later of federal law, known as the SAFE Act, expanding the system, building an examination system and tool, and then beginning to rebuild the original system, Bill has led us through tremendous growth and many challenges. As CEO for the last 10 years of those 16 years, I've been with CSBS longer, I'm really sorry to see Bill go, but I'm grateful for all that he has done to get NMLS and SES and the state system of supervision where we are today. Thank you, Bill, for all the work that you have achieved, and may you finally find, after 6 years of the work only increasing, that maybe some of that work is behind you and a lot more fun ahead. So with that, Jim, I think we're going to hear from Charles Cooper next, a leader in CSBS and a leader in helping us imagine a state system of financial regulation.
Okay, Jim, can you hear me okay?
We can hear you, Charles.
Okay, great. Thank you, John. As John said, my name is Charles Cooper. I'm the Commissioner of the Texas Department of Banking. I've been on the SRR board for several years now and currently serve as its Vice Chair. And I wanted the opportunity to say a few words about Bill before he gets away. So Bill, John said a bunch of nice things about you, so I hope you're sitting down, be prepared. I was appointed about the time the NMLS was launched. I have a distinct memory of wanting to know who Bill Matthews was and what he did. So with the passing of over a decade, I now know who Bill Matthews is, but I still haven't been able to figure out what he does. Sorry, Bill, I had to say that one more time. Actually, I think I figured out what Bill has been doing over these years. After serving on the CSBS Legislative Committee, I became the treasurer in 2012. It's at the same time the NMLS system expanded beyond mortgage to include other industries, such as MSBs. And that's when I started really working very closely with Bill. During my tenure on the board, I watched Bill manage the expansion of NMLS to the full range of financial service industries that are regulated by the states and grow to 64 state agencies. Over these years of expansion, we have continued to improve and modernize as we are doing so today. And I have observed Bill direct these improvements, tackle the problems, work with our board as individuals and as a joint body, manage the budgets, dealing with contracts and sometimes less pleasant legal matters, while keeping the staff of 51 moving in a forward direction. Over this time, I've found Bill to be responsive to the demands of state commissioners while bringing us together to make the state system stronger and more responsive to our stakeholders. So Bill, I think I know what you've been doing for these few years. And on behalf of the SRR Board of Managers and all of the agencies that use the NMLS system, I want to thank you for your 16 years of service and all that you have done to get us to where we are today. And you are not only a true professional, but a dear friend. Best wishes for a well-deserved retirement.
Thank you, Charles. Bill, I would also like to extend congratulations for your retirement and a thank you as well. I've always enjoyed our conversations, brief as they have been, but as I've been involved more and more with different NMLS committees and work groups and things over the years as a state regulator, I definitely appreciate all the work that has gone into development of this system and the relationships that we've developed with each other and working through these common issues. And I understand your team emulates the person you are and the hard work that you've done, and that really does come across. And I just want to thank you a lot for everything you've done.
Well, John and Charles and Jim, thank you for the kind comments. I was not aware this was going to happen, so you're catching me a little cold. And hearing Charles say all those nice things, I'm just, I almost cried. And he is the thing I like about Charles is he's a tough cookie, but once he understands the issue and agrees with it, he's fully behind. And so I've appreciated his support along the way. I was having lunch with Gavin Gee, the former director in Idaho, who came up with the idea of the NMLS, and his wife, Libby. And Libby says, well, what do you do? And I just kind of paused for a minute, and I just said, I try to keep the train on the tracks. That's the job I try to do. And I thought I would be with CSBS for maybe 2 to 4 years, and here we are at 16. I recently got my Medicare card, and so I'm entering a new chapter in life with grandkids and family and whatnot. So I'm excited to move on to that. So, and Jim, also thank you for your comments as well.
Thank you, Bill, and thank you all for that. And we'll move on. So if you guys would go ahead and just click the leave button to turn off your audio and leave the stage. And thanks again for joining us today. So now we can jump into the rest of our agenda. We've got a meeting made up of 6 mini panels. During each panel, we'll have our topic presenter talk about their submission, and then we'll discuss further with the rest of the panel, which is made up of regulators and industry members. We'll also discuss questions and comments that are posed through the chat. These questions will be saved for the end of each mini panel. Unfortunately, due to the nature of the virtual meeting today, we will not have an open forum section where other issues may be raised. But please continue to send those issues by email to ombudsman@nmls.org. So first up, we have Krista Cooley of Mayor Brown's, their submissions related to comments on the proposed prudential standards for state oversight of non-bank mortgage servicers. And joining her to discuss is Chuck Cross from CSBS. So it looks like we have Krista and Chuck both on stage, and I will turn it over to you.
Well, thank you, Jim. That's quite a tough act to follow. So the first thing I'll say is, much like everyone else, congratulations, Bill. an amazing tenure at NMLS, and I'm sure you're looking forward to the next chapter. And I want to thank the CSBS and the NMLS Ombudsman for providing this opportunity to submit questions for discussion. And as Jim said, we're going to start with the CSBS's most recent proposal of the prudential standards for state oversight of non-bank mortgage servicers. And as most of you know, especially if you are a non-bank servicer who's following this issue, the most recent proposal was released at the end of September of last year, and there was a comment period that closed on December 31st of 2020. And I know that a significant number of comments were received by the CSBS in connection with several aspects of the proposal. There are many aspects of the proposal, so Chuck and I, in talking about this and leading up to the meeting, couldn't quite get through all of them, but hopefully we'll be able to get through many. And the first one I thought we could start with is maybe just a brief overview from Chuck on where the CSBS is in evaluating and analyzing those comments, since we don't really have a lot of visibility into that. And maybe you could also talk about the next steps we can expect.
Jim, for hearing this topic, and thank you, Krista, for raising valid questions about the standards. Our goal has been to be open and transparent in the development of these standards, and we seek out opportunities for dialogue on this initiative wherever possible. So this is a great opportunity and sort of perfect timing for us to go a little bit deeper into some of the areas of the standards. Krista asked me to cover the background and the status with you, and I'll just do that quickly. This initiative is part of the CSBS strategic plan formulated by our state commissioners. It was assigned to the Non-Depository Supervisory Committee, or the NDSC, for oversight and direction in the development and implementation of the standards. The board approved the 2020 proposal for these standards in August, and as Krista said, they were published October 1st for comment through the end of the year. We received 17 industry comments. We conducted a number of face-to-face discussions with servicers and industry associations, and we presented on the prudential standards several times. At this time, the NDSC has considered all the comments as well as regulator advice we received during that period of time, and has accepted, rejected, or found compromise on all of the comments. The next step will be for the NDSC to review the final draft of the prudential standards. If they approve the final draft, it will then move to the CSBS board in May, and if the board votes to approve, the standards will become CSBS policy. And I'll come back to that point in just a moment. Although commenters provided arguments challenging the need for these standards and expressed concerns of additional layers of burden on the non-bank mortgage servicing industry, the NDSC has determined that regulatory prudential standards enforceable by state regulators are warranted and advisable at this time. Their consideration included some key observations. First, state supervisors hold primary authority, and by this we mean licensing authority over servicers, and also prudential responsibility, meaning institution financial condition and corporate governance. And this is for an increasing share of mortgage servicing. The state system is charged with establishing effective corporate controls and consumer protection responsibilities for non-bank mortgage servicers. Such controls and responsibilities are only effective when enforceable by the primary regulators. A national set of standards is the most effective format for entities operating in multiple jurisdictions and presents less regulatory burden than multiple unique state requirements will. Second, sound financial condition and safe management practices are essential to performing compliance and consumer protection obligations. Yet many non-bank mortgage servicers are historically thinly capitalized with insufficient liquidity. Additionally, state and federal regulators have identified significant failings in corporate governance and board oversight of institutions. Examinations are replete with findings of documentation problems leading to wrongful foreclosures, accounting problems leading to unreconciled escrow accounts, lost or misappropriated consumer funds, or incorrectly assessed fees. Further, when a servicer fails, loan transfers to a stable servicer are not a simple undertaking. In a best case scenario, transactions are suspended as loans are boarded and issues are sorted through. In a worst case scenario, documents are lost, funds are misplaced, and interrupted payments lead to derogatory reports on consumers' records. Third, requirements and standards established by Ginnie Mae, FHFA, which are implemented through Fannie and Freddie, and other federal housing agencies are not regulations. For non-bank mortgage servicers, they are program requirements that do not equate to appropriate regulatory safeguards, do not provide coverage of all portfolios, and may not be enforceable by states, who are the only regulators examining for compliance, consumer protection, financial condition, and corporate controls. Further, the requirements established by Ginnie Mae and FHFA apply only to government lending programs. They don't apply to non-government lending. I want to return for a quick moment to what these standards will and will not be. These standards, if approved, establish a policy position. While they can be relied on as a model for law or regulation, they are not in themselves law or regulation. That can only happen through individual state undertaking. So with that opening, Krista, let's go back and see if I can provide some answers to questions that you put forth to the Ombudsman.
Sorry, I was clicking the wrong button for the mute. So, and you touched on one of the topics that I wanted to start with, and some of the concerns that we've been hearing from industry and some of our clients as they're reviewing and, have commented on these. And, one of the things that you mentioned was the importance of making, of having standards to avoid multiple unique state requirements. And we have certainly heard a lot of questions about, how once the standards are, finalized, as you've, laid out the procedure that the CSBS will go through in order to do that, then it really will become a matter of implementation and how states will implement those. And so, what we've really heard is how will the CSBS look for consistency in adoption as an initial matter, but then also implementation and enforcement of the standards, because any variations in any of those three areas will create additional complexity in an already very complex regulatory and legislative system that exists today. And so if you could speak to that for a few minutes, I think that would be very helpful.
Sure, and you're pointing this out, and many of the commenters have pointed out that, look, implementation is the key here. It's relatively easy to get agreement on drafting a set of standards. Putting those standards into play will be the big lift for us. If we achieve approval by the board in May, we will spend the summer putting together an implementation plan, which will go back in front of our board in August for their approval on that plan. We don't have the specifics laid out of what the implementation plan will look like at this time, but it will likely come in the form of a menu of options for the board to choose from, sort of a range of things, all the way from states passing explicit statutes or regulations based on the standards, all the way down to using the standards as a model for examination procedures and processes. As far as uniformity, this, of course, is a challenge quite frequently in the state system with 50 plus members to coordinate. This is probably best achieved through one of our committees, and we have two committees in this area that would have oversight over these standards. The highest level one would be the NDSC, which I already mentioned. That's the high level oversight for non-bank supervision. But the MMC is the sort of on-the-ground committee that manages all of our multi-state examinations and deals with multi-state processes and so forth. And so I believe that the NDSC will likely assign the responsibility to the MMC to make sure that states are implementing things in as uniform a fashion as possible. And this will include areas where interpretations are needed under the standards, and also in developing the examination procedures. That will be key as well. So we'll need to update the MMC's multi-state examination manual for what's contained within the standards. And then it'll be incumbent on the MMC to make sure that examinations, multi-state examinations, proceed with those standards that have been brought into the examination procedures. So I think that's how we achieve uniformity across the state system. Part and parcel of this is constant and substantive sharing of information and dialogue back and forth between regulators, and then also between the industry and regulators.
Okay, I mean, that makes sense. And I think it ties into one of the next questions. And also, I think one of the concerns is, without having a solidified implementation plan, one of the questions that we've been thinking through is, as you know, a lot of the financial standards that are in the proposal are intended to align with, as you mentioned at the top of your comments, the FHFA GSE requirements, as well as Ginnie Mae. And I think you said it, yourself, those are not regulatory provisions, right? And so those agencies have and do frequently exercise discretion in how they apply those standards. And I think we can agree, on some of the uses of discretion and potentially disagree on other uses, but certainly there are situations in which a company can hit a rough patch financially, for example, that has nothing to do with their ability to serve consumers or even impacting their ability to serve consumers in real time. But without that level of discretion, if the financial standards become regulatory provisions or the law, and states don't have that discretion, you're potentially running into a situation in which, as you said, servicing transfers are very difficult. They are incredibly complex issues that are created when some of that flexibility that exists in the sort of model that's being used for the proposal wouldn't necessarily be available if these were to become law and regulation. And that's definitely one of the biggest concerns that we're hearing as folks think through how the proposed standards will ultimately play out.
Yeah, thanks for that question. So I want to cover, I guess, a couple of major points under this topic of discretion and possibly flexibility. I think first, the fact that the industry acknowledges that there is this discretion by the federal agencies and the application of their standards is actually a supporting argument for the state standards in this area. We've learned quite a bit about the federal standards as we've investigated bringing these state standards into place. It's a fairly frequent occurrence with the federal agencies to grant waivers or to choose not to enforce certain sections of the standards. So for us, that's an argument as to why those federal standards are not really standards for our purposes. They're program requirements that can be sort of turned on and turned off based on each agency's subjective determination. And when you have three primary agencies doing this turning on and turning off, and in the first place, their standards aren't really consistent among themselves, this just creates even more unevenness. As far as state regulators being flexible on this, let me try to phrase it this way. If these become part of statute and rule, there is less flexible opportunity for state regulators and whether a violation has occurred. But the citation of a violation isn't the end of the story for a company. So if a company has had, for example, a deteriorated financial condition that would find itself in violation of the requirements in these standards, the question would be at that point in time, what would the regulators do about it? Okay, so regulators have several tools in their toolkit. One of those is to work through the examination process, which is a lot of dialogue back and forth between the entity to get the entity to voluntarily bring its standards up to the point it needs to be. It might involve some monitoring and some assistance in directing the company to that point, possibly even looking for outside assistance, third-party assistance to work with the company. But it's very much a back and forth and cooperative undertaking through the examination process. If that doesn't work, then state regulators, of course, have enforcement at their disposal. But implicit in the enforcement environment is some flexibility. Regulators make determinations, all the time when they're looking at enforcement actions. How that will be enforced, what the remedies will be, whether there would be penalties associated with it or not. So there's a high degree of flexibility for state regulators at that point in time. So I think that regulators can't simply say, like a federal agency might with their standards that there is no violation of the standards because a waiver is granted. They can certainly say a violation has occurred, but here's what we will do to work with the company to either bring them in compliance, say over a period of time, or if necessary, conduct an enforcement action with these determined parameters in place. And in most cases, these are probably going to be multi-state situations. And so it's going to be a collaborative group of states working together, or the MMC or the NDSC coming together to make this determination. It's unlikely that it will be a single state making a determination about the enforcement of the standards.
That's definitely helpful background, and it kind of brings us to another discussion point that we talked a little bit about in preparation for this, and you touched on briefly, which is, you know, in addition to the potential for inconsistency, you know, you've mentioned now a few instances in which, you know, the multi-state exam process does work and states work together, and we have seen examples of servicers that have been, you know, penalized and asked to change their processes, and some of the governance standards, in addition to the financial requirements that are in the proposal, have really already been exercised by the states as part of those you know, past examples. And so I guess one of the questions that we also get is, and I know you sort of said a few words, but if you could expand maybe a little bit on, you know, is this really necessary, right? If the states already have the power and the authority to implement their requirements, not just the state level, but also federal laws that may, you know, impact servicing, like the CFPB's regulators. And those are very clear, consistent standards. You know, what additional purposes the proposed standards really going to serve when states can only do, you know, what they can do now to enforce the requirement?
And I apologize, Krista, you were breaking up a lot there, so I'm going to see if I can interpret what your question was and provide an adequate answer. So, so when we did speak before, we talked about some deeper reasons as to why these standards were important to us, and some of the arguments that the industry had raised against these standards, and why the NDSC still looked at the situation, determined that standards were appropriate. One of the first arguments that that industry raised in objection to the standards was that these types of standards are not really relevant to non-banks, that that they're more relevant to depository institutions where there's federal backstops in place, and there are taxpayer funds at risk. And that's not the case with non-bank servicers, so therefore these standards probably shouldn't be considered relevant. There's also a lot of argument that the Fannie, Freddie, and Ginnie Mae requirements are adequate, that we don't need additional layers of standards on top of what already exists. And then finally, there's an argument that several commenters put forward that says that the market effectively self-polices for safe and sound operations. And so therefore, it would be better if the state regulators just stayed back and let the market take care of these issues. So we believe that we've thought about these thoroughly and have answered them to our own comfort. But what you need to know is that while it's true that prudential standards have traditionally been applied to depository institutions, and they focus largely on protecting customer deposits at banks or credit unions, and that there are federal backstops associated with those deposits. State regulators have developed these standards specifically as protective measures for consumers, as well as the institution and the market overall. Non-bank mortgage servicers annually receive and hold and disperse billions of dollars in consumer funds, the mishandling of which holds significant potential harm for consumers with no government insurance fund for protection like you would have in a depository world. Further, the supervision of troubled and failing institutions require considerable state and federal resources to address that situation. Finally, consumers typically have no representation in the resolution process. Although you'll see forced bulk transferring of servicing, which poses ongoing risk to consumers, especially those engaged in loss mitigation or other special circumstances, the consumers themselves have no voice in that process, just as the consumer never has a voice at the beginning when they end up with a specific servicer They don't really get to choose like you do with other financial services. As to the argument that Fannie, Freddie, and Ginnie Mae have adequate protections in place, we argue again that these federal agency requirements are not really regulatory requirements. They're designed to facilitate the market, and they're not designed to protect consumers. And it's important to note that institution compliance is required only when the institution chooses to participate in a particular program. An institution choosing to not service loans in one of these programs is simply not subject to the coverage of that program. Further, even where these standards do cover, the standards established by the agencies are not consistent, as I said before, and they are not reviewed by regulators. They may be reviewed by auditors that work for these federal agencies, but they're not reviewed as a regulator would review them. And they do not apply to non-agency servicing portfolios, an important point for us. So absent the state standards, there is no regulatory standard for financial condition or corporate governance for non-bank servicers. And finally, just on the topic of the market self-policing servicers, this statement is just simply incorrect, which is evidenced by the volume and size of consumer protection enforcement actions and class action suits against servicers in the last decade. Market controls are influenced by profitability and self-reporting. Counterparty covenants and creditor monitoring not only are not the purview of regulators, this information is rarely, if ever, provided by servicers in the examination context, despite fairly widely held perception that this information is readily available. It's not readily available to the regulators. While bankruptcy is an effective long-term resolution of a failed institution, that effectiveness is really for creditors and commercial counterparties. It's not an effective or efficient mechanism for consumer protection. Bankruptcy is focused on creditor protection. And consumers that are inadvertently caught up in bankruptcy proceedings of a servicer may experience uncertain management of their loans and lost, unaccounted for, or extended delays of refunds that are owed by the servicer. And a consumer may be completely unable to access crucial documentation from the skeleton servicing staff that's winding down the bankrupt entity. So hopefully I got your question right. Again, you were breaking up quite a bit there. And if not, please redirect me on what your questions were.
Thank you both. We have about 1 minute left. So Krista, any final thoughts before we move on?
Yeah, and hopefully I won't break up again. I apologize for that. I do think you addressed the question. I will say that in representing servicers in exams and enforcement, I think there is a phenomenal amount of oversight on the servicers right now today. And I don't think anyone expects that that's going away, particularly in the servicing environment that we're in. So I appreciate your comments, but I will say that I think the states and the federal regulators are doing their job very thoroughly in making sure that the various requirements that the servicers are subject to today are being enforced and being monitored and maintained. And I like to think servicers have done an amazing job, particularly in this incredibly difficult environment, to provide assistance to consumers who need it and qualify for it. I guess the only other thing that I would ask, if we have time, and Jim, this is totally up to you, is you mentioned at the beginning that there were some things that the CSBS panel who is evaluating the comments had either accepted, rejected, or maybe compromised on. And obviously, I'm sure you can't talk about everything, but if there's something that you could just sort of let folks who are on the call know that this is where we've landed on certain things. I know I would appreciate hearing that, and I hope others would as well.
Jim, do you have time for a few of those?
Maybe 30 seconds or a minute, if you can summarize quickly.
Okay, and I'll just do this off the top of my head. Some of the things that I know that will be coming. One of the biggest ones that people asked about was, will there be a de minimis cutoff for a point of size that will have somebody covered by the standards? The answer to that is yes, the NDSC considered an appropriate cutoff, and that will be in the final standards. And I think that the cutoff will be such that the concerns about the very small servicers will not be that relevant. For the most part, these will be servicers who are already Fannie, Freddie, or Ginnie approved. They're already under some pretty serious financial condition requirements and other corporate governance requirements. So I don't think there will be much of a shock to those institutions. So I think that's good news for the small guys. there are some areas around financial condition and alignment with the federal agencies where the NDSC did a lot of consideration about what that alignment looks like. There was a concern, it was actually in your question about a higher of standard, where we had initially published that we would take the current standard, and as the standards went up, we would go up with them, but then it didn't automatically come back down. So the NDSC did some consideration around that and came up with a solution that we think will work, which is not sort of an arbitrary move up or move down, but the regulators will have the opportunity to consider the environment of having moved up or moved down, and we'll assess that against consumer protection needs and determine whether the standards should actually change or not. So those are
Thanks, Chuck.
the commenters asked about. So
Yeah, thank you, Krista, so much for the time. And we have to move on, but I look forward to continuing this discussion. So thank you both again for talking about this important topic today. And if you'd both please click the leave button to come off stage, and we will move on. The next topic we have is regarding advanced change notice challenges. So we've another submission from Mayor Brown, this submitted by Robin Gieske and Jeffrey Prost. And it focuses on some challenge related to the processing of changes that required advanced change notice. Robin will be joined by Casey Shaler from the Idaho Department of Finance, Rhoda Ricketts from New York Department of Financial Institutions, and Stephen Frummeltz from the Arizona Department of Insurance and Financial Institutions. So if we can have Robin, Casey, Rhoda, and Stephen, please join me on stage by sharing your audio and video. Hi, Robin. Hi, Stephen.
Hi, Jim.
Hello.
Casey, can you hear us okay?
Yeah, I can hear you. Can you hear me?
Yes, we can. And Rhoda, if you're here, would you please click the blue button in the upper right to share your audio and video? All right, Robin, let's go ahead and if we can just start talking about the topic, and hopefully she'll be able to join here in a few minutes.
Sure. Good afternoon, everyone. My name is Robin Gieske. I'm a regulatory compliance analyst with Mayor Brown. Thank you for your time today. I'm super excited to be here. I am a big fan of the Ombudsman meeting. It's my favorite part of every conference, and I'm excited to have the opportunity to present. So in the interest of full disclosure, I am a talker, and when I'm nervous, I talk more. So I have actually prepared something that I'm going to read from to help myself stay on target, and I hope you'll all bear with me. My colleague Jeffrey Prost and I submitted the topic of company name changes for conversation. It's something that can be a difficult process, and we're hoping to start a dialogue with state regulators to allow for a more uniform approach to how the states process name change filings. For the purposes of discussion today, let's focus on residential lenders and brokers while recognizing that this is something that affects all companies that maintain licenses in the NMLS. So the NMLS makes it easy to tell each regulator that a licensee is changing its legal name. A company files an ACN and submits any supplemental documentation. Bond writers, corporate resolutions, processing fees, all easy. These are all documents that can be submitted in advance with a future effective date. But the Secretary of State filings cannot be submitted in advance. And of course, everything revolves around this approval. Secretary of State registrations are real-time and do not offer a useful and amazing ACN feature like the NMLS does. Companies can prepare the appropriate forms in advance. They can file name reservations, obtain word approval, and even confirm that the company is in good standing with the state, but the companies cannot actually make the name change filing until the actual effective date of the change. So essentially, on the date of a name change, a company may have up to 50 Secretary of State filings, plus DC and Puerto Rico that have to get filed, and evidence must be received the same day from every state to have a seamless process. Making things more complicated, each Secretary of State filing is contingent upon first receiving evidence of the name change from the company's state of formation. Here's the rub. Secretary of State offices do not have a system as efficient and fantastical as the NMLS. Not every Secretary of State office is using an online processing platform, and as a result, and perhaps even more evident due to the pandemic, many Secretary of State offices do not have a fast turnaround time. Many of them don't even offer expedited service. Last summer, as I'm sure you're all aware, processing times were especially lengthy. And when a state regulator is unable to approve a name change until they have received the updated Secretary of State certificate, the company ends up in a really difficult position. The NMLS updates to the new name on the effective date. And while it's great that the NMLS lets a company tell all of the states at once about the name change, it also means that it amends all of the states at once. If one state hasn't issued an approval, the NMLS doesn't give me the opportunity to check a box to say, I won't use the name in this state. It's all or nothing. And as I mentioned before, the first thing that gets filed are the amended articles in the company state of formation. Once that's been processed, that means the company name has legally changed, and the NMLS should match to reflect that. For a project our firm worked on last summer in a small number of states where the Secretary of State processing times were drawn out, the company was told they could not use the new name until it's approved and that they should suspend activities. In other cases, the states allowed the company to close out their existing pipeline under their old name, but would not allow the company to take any new applications. This had a negative impact on the company and was especially hard on the MLOs, who are largely commissioned employees. It also made things confusing for borrowers looking to vet their lender in consumer access. They were looking for the old name, but the system's already turned over, so the new name is what appears in consumer access. I don't really know what the answer is to avoid suspension of activities in a particular state, but I can speak to how some states handled this process. In a few of the states experiencing delays with the Secretary of State offices, the regulators were able to provide authority to operate under the new name on a temporary basis, with the understanding that the Secretary of State documentation would soon follow. And all of this brings me to our question. What is the specific thing that prevents you, the state regulator, from issuing name approval until you have that certificate in your hands? And can it be changed? Thank you, everybody, for sticking with me through that. And I look forward to your comments.
Thanks, Robin. I can get it started with Kansas's perspective. So your specific question about what would prohibit a state or our state agency, in our perspective, from issuing a name change on a license, there's not much that prohibits it in our statute. It really is given to the commissioner. The bank commissioner oversees the statute, and we talk about name changes as a matter of practice, knowing that they can occur. But as far as changing the name in the record, the process that we go through is probably similar in other states, that we make sure that the name is unique and not the same as a different licensee, that it doesn't have some trigger words like bank or trust company and things of that nature. And then we also, as you said, we expect that the name would be updated at the state level for under the Secretary of State. But in terms of changing the name, we really have that authority here to change it based on those conditions that I just mentioned. So we had in the past had issued paper licenses and mailed them out. Then we converted to PDF licenses and emailed them out. And now we're converting solely to the NMLS as a reflection of the updated information. So in our state, it appears to work best when the NMLS is updated on the date of the change to reflect the new name. However, knowing that it is a fluid process across multiple states, that is something that we should talk about, given that the company is in multiple jurisdictions. I think from my perspective and my just my personal opinion, it seems to work well when all states see the same thing at the same time, better than to have a process that's a little more choppy, where you're in one state this way and another state that way and so forth, which is more kind of akin to a DBA name or trade name usage. So, but in terms of the legal name of the domestic state, I think it makes sense to have the system reflect what that domestic state has approved in terms of that jurisdiction, in terms of the name. So well, with that, I open it up to the other regulators in this panel, and would ask you to please talk about your process and your state rules.
Hi, this is Steve from Holtz from Arizona. When I first got this question, it confused me a little bit too. Being fairly new to the financial enterprise licensing, I wasn't sure exactly where the intent of the question was. So I dived in a little deeper to what our processes are in Arizona, and I found that I think one of the reasons for the holdup in Arizona getting approved through our Corporation Commission, which is a version of Secretary of State, is that there is a fee involved with the name change. And the Corporation Commission also approves the name as well. So I believe from a historical perspective, the reason that we waited for the ACC approval is in case they denied the use of the requested name. Because if we change the name before they do, then there could possibly be a second name change involved if you have a forced name that you have to use in Arizona or something along those lines. But I've looked at that, and hopefully there'll be legislation coming forward this fall that eliminates the cost for a name change, which I think would help us alleviate our issues of having a name change come through, processing it, then the Corporation Commission denies the use of the name, and so another name has to be submitted, which incorporates another fee has to be paid to us. So if that does go through and we're able to eliminate the name change fee, I definitely think this is something we could reevaluate and process a name change prior to our Corporation Commission doing it, as long as it's been changed in the domicile state and officially legally changed for the entity. So I appreciate you bringing the question up, because a lot of our processes may be historical processes that we haven't revisited lately. And I think this could be one of them. So I can't say, next week, next month, we're going to change the processes, how we do it in Arizona. But I definitely see probably within the next 6 months or so that it's definitely something we could move forward to, of getting that name changed on the license prior to getting the approval through our Corporation Commission.
That would be wonderful.
So-
Thank you, Stephen.
So Stephen, how does the system, the way it currently functions, impact that ability, or is the way it's working now just fine in terms of your perspective?
The way the system works, yeah, there's no issues or concerns from that perspective at all.
Okay. Casey?
Yeah, I'm Casey Shaler with Idaho, and while we have prohibitions in our statute about using a name that hasn't been approved for business, we recognize the similar points have already been brought up, that you have multiple state and agency approvals that are involved, whether it's through Secretary of States, through domicile states, and then the new state they want to come into. We decided to go with kind of the NMLS policy of having everything done within 30 days of an event change. So what we would look for, once we get the ACM, we would notify that it would be approved, but subject to the receipt of all final documentation, evidence of the name change through the Idaho Secretary of State, domicile state, to be filed within 30 days of that event closure date, whenever that actually occurs. So we would expect to see the doc uploads at that time. We're lucky we don't have the issue that Stephen has. We don't charge a fee for that. Granted, our Secretary of State does, but we don't. The Secretary of State has converted to an electronic process. There is a wait time that they post. Of course, they don't, right now, it's not evidencing whether it's delayed due to COVID or not, but they do have rush fees. Their standard time frame is around, I think, 7 to 10 days, the last I saw. You can rush 2 different levels, one to about 48 hours and one supposedly within 8 hours. But we look at wanting that business continuity to keep going. We don't want to be part of an interruption in business. So during that 30-day window, we do allow business to continue in the new name. At the end of 30 days, there might be some conversations being held at that point, but we generally don't run into a problem with that. And that keeps the LOs being able to originate or in our other industries the same way.
Thanks, Casey, for those comments. Looks like we have Rhoda on. Hi, Rhoda.
Hi, how are you?
Pretty good. How are you doing?
I'm good. Hopefully I stay stable for a few minutes.
Sure. Yeah. Would you like to give us New York's perspective on this issue?
So in terms of the new name, because of the rules in New York, we can't actually tell a company that they could utilize the new name until it's approved. They have to have authority in the state of New York if it's a foreign company to conduct business with us, in the state of New York, and it has to be filed with the Secretary of State. Our law actually also prevents them from using any name that's not issued on the license. We have lead time that we've given company in hopes that what it does is it allows us to
Hi, Rhoda. It's cut out for me a little bit. Are you hearing us?
prep the process. It's a few minutes. Can you hear me now?
Yes, we can. Thanks, Rhoda.
Right. Yeah. So we do have lead time, and we try our best to have it prepped and everything and ready for once the document is filed, we can flip over. The challenge is it's a
It stopped again, Rhoda, on our end.
mortgage transaction. It's a contract.
Okay.
Okay,
you're
I'm going
back.
to try to be quick so it doesn't cut out too much. So because it's a mortgage contract, what can happen is if they use the new name, they could actually be giving someone a free mortgage. And so that's why we never send out any communication that says, yes, you can use the name. In
Rhoda, maybe try to leave and come back. We will get into the next issue here quickly, and then
terms of so I'm gonna jump out. I'm gonna jump out. Unfortunately, I was stable for a long time, and the crash I think is causing a problem.
Sure. Yep. Hopefully, we'll get you back here soon. So the next issue we had was about control persons. If they leave the company before the license item is cleared, the issue is that the license item is cleared based on the submission of the MU2, but if the relationship is ended before the license item was cleared, they're unable to submit. And with the March release, upon the approval of access to the company, the related license item will be automatically cleared. So this means if the company license has an item requesting that their direct owner, John Smith, to update his employment record, and John Smith leaves the company abruptly without warning, as soon as access is removed, the license item will also clear. So.
Thank you. That has been vexing me for quite some time. So I love that I sent a letter in March and it got taken care of in April. I feel very efficient.
Great, great. All right, well, I think let's look and see if we have any comments from the chat on this issue before we move forward. So it looks like a few industry members have agreed with Robin's comments and thanked her for bringing it up. Jeffrey Prost from Mayor Brown noted that they have run into this issue when a licensee converts from a corp to a limited liability company, as we're merely amending the corporate indicator. And someone else did ask a question. Let's see. Stephen Sheesby asked, what issues do you see with the domiciled state name being filed a few weeks prior to the name change taking effect in the NMLS? This would then allow time for the foreign amendments to be filed by the effective date in the NMLS. However, I understand this may create some conflicts. Any comments from the panelists on that question?
Not really too much of a comment on that. You know, if it's changed prior in the from the domicile state, and it's done prior to going through the Arizona Corporation Commission, you know, we're right now as current state, we're looking at the Corporation Commission within Arizona, Secretary of State within Arizona, to process the name change. So we wouldn't tie those two dates together in our current process. We're looking to see the approval in Arizona. So it sounds like a good idea, because that would at least, you would have a few weeks lead on the Secretary of State Corporation Commission to process that name change, to get it through before requesting to us. Yeah, so I'm not sure I'm fully understanding that question, but you know, any way to get the Corporation Commission to speed along a little bit, and if that means you would get a few weeks before the actual use of the name in Arizona, that could be helpful as far as getting approval from us faster.
I would echo that from Kansas perspective. I think this might be a question, however, for the respective Secretary of States and their process. I don't know if there is a timing requirement to update the respective foreign filing in our state, if the domiciled state is, say, Delaware or whatnot. But there are nothing in our mortgage or consumer acts would prohibit the domiciled state name changing prior to the time in which they changed the license. So,
it wouldn't be any different here. All of the name changes and name reservations or anything like that is controlled with the Secretary of State. So I don't know if they'd have an issue to something that's predated. I know they take name reservations up to 4 months, but I don't know if the date of what they put on the domicile documents would have any impact on that.
Yeah, same here. It's a question for the Secretary of State, I believe.
And I think that comes into a larger issue then, just from a company perspective, that you know, this is their legal entity name, and to have something that doesn't match their legal entity name under which they're doing business, I think it starts to get a little messy and confusing. And Delaware is a very efficient state for if you're domiciled in Delaware, but there's other states where, you know, I might file as far in advance as I possibly can, but it's going to take, it could be a lengthy period of time anyway to get it. And we still might be falling into the same process where we're getting behind anyway. I don't necessarily know that filing in advance and existing under a name overall that you're approved under, but in each state you're existing in a different name. I don't know that that's necessarily something that entities would be comfortable with.
Sure.
Or allowed to do.
Sure. Now, I do think, yeah, the system can't do anything about that question necessarily, but it can trail if states have, you know, if, like you mentioned, after the fact, you've got a state where you've got to keep working in one name versus the other, or you've got a temporary name, you know, to keep business going until the filings go through. Perhaps there's something the system can reflect, you know, as a period after that initial change with the domicile state, to reflect which states and in what status you're in those states. Maybe something of that nature can be reflective. Currently, the setup is it's not public whether each state has been approved, or each state has approved a name change. So, but maybe something that goes out that shows the varying statuses is something that we could, you know, discuss moving forward, or something along those lines that gives some transparency into the fact that you're in different, you know, under different names in different states.
Right. I'm still waiting on approval from these states, but in these states I'm doing business under this name.
Right.
It's similar to how the DBA filings are recorded in the Form ME1.
Right.
I think could be useful. Absolutely. Because setting the transaction date back, setting it back and saying, okay, I won't change my name on this effective date, I'm going to set it back a few days later because I still don't have an approval. That's not a choice, right? All of my filings have been made. I'm moving forward. I'm using this name. It's just a matter of breaking it down state by state, and how do we make the NMLS reflect that?
We do have one more question that we might be able to get to quickly. Dana Lopez asked, can states give temporary approval status of the legal name while it waits approval from the Secretary of State? For Kansas, there is no authority to provide a temporary approval status. I think what's happening here is that we are taking the NMLS name change on the day that it occurs, and that is our license. So whenever that goes through, it's approved. Like I said, regarding the different conditions I mentioned earlier about confusion with consumers or having those trigger words that are not allowed. But we don't have a specific authority to give that temporary approval. But like I said, we are using the NMLS as our system of record in that capacity. So as soon as the name changes there, it's changed for all of Kansas licensed business.
I would echo that as well. We in Arizona wouldn't have that type of process or ability to do that type of thing.
That would be the same in Idaho, but that's one of the reasons that we did go to that 30-day post-event window, just recognizing there's going to be time fluidity issues in the various states. And it's not necessarily an approval of the name, because that's not our authority to give, but it's allowing the use of it for that 30-day window while the documents are getting approved in that process. And we're not looking to take an action during that time period.
Right. Okay, well, great. I want to thank the panelists on this topic, and I appreciate the continued dialogue and look forward to more in the future. So I think we're going to try to move back on to our next panel. So thank you all, and go ahead and click the leave button, and we'll talk soon.
Thank you.
Thank you. Next, we'll hear from Kobe Pruitt from the Mortgage Bankers Association on the future of remote notarization. And Kobe, if you'll join me on stage by sharing your audio and video. Hi, Kobe.
Hi, how are you doing? Can you hear me?
Yes, we can.
All right, great. Good afternoon. My name is Kobe Pruitt. I am the Associate Director of State Government Affairs at the Mortgage Bankers Association. And before I just introduce my topic of discussion, I wanted to take a moment to thank the regulators that have come and attended this meeting. You took the time out of your busy schedules to give the industry the opportunity to meet with you face to face, and we do appreciate it. And with that, today, I would like to spend my time discussing the growing concern by many members of the real estate finance industry regarding state adoption of remote ink notarization, or RIN, and why it's not as safe as remote online notarization, or RON. This will be a little bit more informational, but this topic is important for the regulators in attendance, because you may soon be asked to provide your opinion on the matter, and NBA would like to provide you with information on what makes both of these types of notarial acts similar, but most importantly, what makes both of these notarial acts different. At the beginning of the 2020, the COVID-19 health crisis caused a paradigm shift where in-person financial transactions were severely restricted and prevented documents from being notarized in a traditional manner. In response, many states issued temporary executive orders to authorize the suspension of the state's statutory requirement that the principal physically appear before a notary. Many states allowed notaries to view the signing of a paper document through an unsecured audiovisual communication tool. This, for example, Zoom, Microsoft Teams, WebEx. The paper documents were then signed and transmitted electronically or through postal mail by the principal to the notary. These transactions were dubbed RIN, or remote ink notarizations. This is completely different from the widely accepted industry approach of remote online notarization, RON, which is based on core principles, including, not limited to, the recognition of consumer choice in using RON. So this is this fact that the principal does not actually have to use RON if they do not want to. The recognition of a consumer, the RON should receive the same legal status of traditional notarization, in the sense that a wedding notarization is the same as one that's done electronically. The inclusion of robust provisions for ID proofing and credential analysis, the acknowledgement of that these notarizations were performed online and are readily identified, distinguished from those done in person. So When you see it in a file, it would say this was done by using a RON. And also that the technology requirements should not be so specific as to favor one vendor over another, creating somewhat neutrality on and not allowing one vendor to dominate the industry. Also, nor should the restrictive the regulation standards be so restrictive that they impede the evolution of ways to improve security over time. And the legislation should conform to other legal standards and laws. All these factors combine to ensure consumers are not at risk of having their legal documents deemed invalid once they're done doing a final check of the transaction. However, due to the ease in which RIN transactions were done during the pandemic, many state policymakers have started to believe that RIN represents a viable way to remotely notarize documents long term. Some states have already introduced or enacted legislation that will codify these temporary state executive orders to allow RIN to be a state statute. This creates a lot of concern for NBA and its members because RIN transactions do not require the same level of consumer protections for remote notarization that RON was developed to address. Most importantly, RIN transactions do not include the multi-factor identification and security standards necessary to protect consumer data or personal information. Moreover, enabling RIN as a method of notarization long-term could potentially create confusion in the market. The GSEs have only provided guidance on a short-term basis to really address the needs of the pandemic and allowed RIN transactions. They did not necessarily foresee RIN continuing past the health crisis that it seems like we're starting to get out of now. The GSEs could likely put a sunset date on their guidance, and states could be left without a way to remotely notarize documents that could be purchased by the secondary market if they try to codify RIN into state statute. So we say all that, but what is NBA really doing on this RIN versus RON issue? NBA is currently advocating against 3 RIN-only bills in three states: Alabama, Arkansas, and West Virginia. Unfortunately, the West Virginia bill was passed by the legislature and it will likely be signed by the governor. I don't see any issue with that. Or not only see any issue with the governor probably signing that into law. We do have an issue with the fact that it's RIN only. Recently, we did also see in Wyoming that they passed SF 29, which enables the use of both RIN and RON in the bill or now law. But the most important thing about that law is that the RIN standards were required to follow the same standards as RON, which include the multi-factor identification, as well as the security standards, which we as NBA like to see in all states. NBA recently met with the Wyoming Secretary of State to discuss the rules to implement SF 29. Sounds like they're interested in making sure that the RON and RIN standards are similar and making sure that they are protecting consumer information. We've talked about the MISMO standards, which NBA has produced through our subsidiaries. But even then, with so many states that are interested in RIN, there is still momentum towards RON being adopted across the country. We are currently at 30 states with legislation that allows for, or 30 states with laws that allow for the use of RON in that state. This includes 7 states since the start of the pandemic. We are also happy to see that legislatures in New Mexico and Kansas recently passed RON legislation and await signatures by their respective governors. This would make them the 31st and 32nd states with RON. In addition, states of Montana and Virginia, which were early adopters of RON, recently amended their state statutes to be consistent with the national consensus for RON adoption. There are also efforts to get RON passed at the federal level with the Secure Act. The Secure Act is a industry-supported bill that would allow all 50 states to use RON as long as they abide by the nationally accepted standards for RON implementation. Once a state passes their own law that follows the federal bill standards, that state statute would govern. So that's a lot of information.
Sorry, we just have a couple minutes, Kobe. I did want to ask real quick. The Uniform Law Commission has a site posted that's tracking some of these bills. Is that a good resource for the RON legislation?
Yes. So the most important thing to know about the Uniform Law Commission, they're a nonpartisan entity that has their own nationally accepted standard of how to complete a RON transaction, which the NBA Alta model bill that we developed is consistent with. Their model is called the Revised Uniform Law and Notarial Acts. We worked with the ULC to make sure both ways are consistent. The only difference with RULONA is that it is more comprehensive. It includes both electronic notarization, so signing on an iPad, as well as RON. And that was an update that was done in 2018. And our standard is mostly just following just RON transactions.
And we do have one question in from the chat, if you're willing. We have watermarks been applied, was the question.
And is that, I guess the issue about watermarks being that it's applied to indicate it was a RON, maybe? I would assume.
Maybe,
but
yeah, it's April Cunningham from the chat just asked, have watermarks been applied? And she says the more you look at it, the easier it will get, but she also pasted a link about it in the chat, so we have some more information.
But no, I think one of the most important things that we always are advocating for in states is the indication, like I said before, the indication that a RON is a RON on the document. You know, and one of the things that we are fighting for in states that are introducing, say, RIN only legislation, one of the things that we would like to see amended in that bill, in those bills, is to indicate that this is a RIN, which would provide that knowledge to a lender that this is separate and different from a RON transaction, and they can make their own decisions about whether they want to accept that transaction done using a RIN transaction, knowing that it's not necessarily consistent with the national standard.
Sure. Well, thank you so much, Kobe, for the time and the discussion on this topic. And we need to move on. And I appreciate again you joining us today. So
thank you.
Thank you. All right. So next up, we will move on to the return to office protocol and agency guidance. Lastly, the last set of topics and panels that we'll discuss relate to the COVID-19 pandemic, immediate concerns returning to office, advance notice related to changes in current branch licensing requirements, and recommendations on how states might address short-term and long-term needs of their licensees. To discuss these topics, I'll be joined by Nicole Chambly from the Texas Department of Financial Institutions and a member of the NMLS Policy Committee, Jed Bellman from the Maryland Office of the Consumer Financial Regulation, a member of the NMLS Policy Committee, and Rashunda Kelly of the Mississippi Department of Banking and Consumer Finance, and a member of the Non-Depository Supervisory Committee. So if Nicole, Jed, and Rashunda would join me. Hi, Nicole. Hi, Rashunda. Hi, Jed. And yes, we have Cindy Corsaro with Promontory Mortgage Path, LLC. Hi, Cindy.
Good. Hello, Jim. Thank you again for the opportunity to present on this very timely and important topic. Thank you to the Ombudsman, as well as the regulators that will hopefully hear our concerns and help us through this. I work in the mortgage industry for a mortgage fulfillment services company, but I'm pretty sure I speak for all represented industries in the NMLS on this particular topic. So as the vaccine is more widely rolled out and more states begin to expect us to resume routine operations by lifting the COVID-19 exemptions that were in place since last March, I feel it's important for regulators and industry to address a smooth return to the office. Now, this is daunting when you think of how many people are registered and licensed across the NMLS. Speaking from the mortgage side, I think the regulators did an amazing job last year of putting executive rules and exemptions and exceptions into place that allowed us all to work safely from home and also from unlicensed locations. However, these exceptions are going to expire, some as early as May, I believe. So how do we address and determine guidelines for licensed entities so that we can all return to the office in a very organized, streamlined, and compliant way? So my first question is regarding a single state that requires us to be back in the office. So once a state requires an in-office presence, will that mean everyone in that office has to return to work, even if you are not at that moment in time doing any activity in the state that requires your return? That's my first question.
Sure, and I'll kick it off with that. In Kansas, the answer would be no. Another state requiring an in-office presence would not impact our own state. So each decision on whether licensed activity is occurring with our consumers would rest with our state alone. And I'll open up to the panelists to give your thoughts as well, please.
My response, our response from Tennessee would be the same as Jim in Kansas. It would depend on Tennessee.
Same for Mississippi, state specific.
Same here.
So will there be remote access? Will there be some flexibility in some people returning to the office, some people staying and working from a remote environment, or will that kind of be an expected everybody back?
Again, I think if you're asking Kansas specifically, well, it depends on the licensed activity that's conducted. So honestly, the licensed activity could be conducted by any employee of the company, but obviously not all employees conduct licensable activity. So depending on where the licensed activity is occurring, I think that's the question that you would ask. In our state, we would only be answering the question based on our state statute and whether it was Kansas activity occurring. So you could, for instance, have a Missouri branch that opens back up that has no effect on Kansas activity if those LOs in Kansas are still working remotely under a guidance or whatnot.
Right.
I would say Maryland, we issued emergency regulations to allow for remote work, with the goal of also we issued simultaneously proposed regs to make it permanent. Those regs allow for remote work for all employees as long as you meet the standards. It's not deemed working at a licensable location. The only standard that really does mandate an office is you still have to maintain a principal executive office as part of that regulation. But otherwise, all employees will be allowed to remote work if you meet the standards. And I can say that since we didn't get any negative comments, our goal is to go to final regulation within the next few days. I think about 8 to 10 days.
And Mississippi is similar to Kansas.
Okay.
Cindy, we're having a
leads to
little
my next question nicely, which
Okay,
is when
great.
one state, and I think you may, are we back?
Yes,
As
you are
I
back.
say,
So,
can you hear me now?
yes.
Okay, all right. So, and I may have, but I'm going to put it out there anyway, was when one state requires an in-office presence for licensable activity, will any of the other states expect and everyone to be back for all of their states? Or are we really going to adhere to the executive rule dates, the exception dates, et cetera, that have been put forth since last year and are constantly being updated?
I think that kind of echoes a little bit of what we said on the first question, is that regardless of another states require requirement of an in-office presence. It will not impact a Kansas decision. Our guidance was based solely on Kansas activity and whether that's occurring from a company designated alternate location or from the residents. And that's the guidance that we've been extending during the pandemic, and is still in effect.
Yeah, I would just say it doesn't impact Maryland. Obviously, we went through the policy process and determined that we would try to create as much flexibility given a recognition of the workforce of the future and the huge investments made by companies as a result of the pandemic to kind of really heighten their security protocols to facilitate remote work for their employees. However, if a licensed location has dual licensing and certain employees are required to work from that location because of a different state, doesn't really impact our law because then they would be working at home. So, excuse me, they'd be working at that location that presumably would then be licensed.
Right. So you see how it may be confusing for entities, because when one state says everybody back, even though the other states, you're telling me we don't have to be back, it looks like we'll all have to be back. And that's the tough part of the transition back to the office that I'm trying to address today.
So I'll interject here and say something. I think everybody on this call is from different states, with different governors, with different scopes and scales of vaccinations and being open. I know Mississippi, we're all open pretty much. So I can measure my regulatory approach to our licensees based on here. And that executive order that gave me the authority to extend the interim guidance was based on our emergency declaration. And I will say that our declaration is still in place. We did not put a date on our declaration for interim guidance.
Right.
The governor just extended the declaration yesterday to the end of this month, and it's likely going to be extended again. So I think we're limited as regulators also based on the interim authority given to us by our governors based on this event. So I think we're being responsive, but I just think that there will be complications in deploying resumption that we just can't control. But I do think as states, we're aware of that. We're aware of that burden that you're hitting on, and I totally agree. But I think we can collaborate, we can communicate, and I think we are as states on how we're doing this and how we're going to approach the resumption of on-site for industries. And I plan to give advance notification of when this is going to happen. So I hear you, I understand that frustration, but I don't think there's much as regulators we can do because we're basing a lot of what we have given based on our governor.
Yeah, and I think that's a really important point, Commissioner. I think that if you think about this, Cindy, the real basis for emergency powers is directly related to the health crisis. And so as the situation changes, which is also very state specific, possibly even, more local than that, we are constrained, and the governor that's authorizing us to operate under that executive authority is constrained by the realities on the ground. And we don't want to end up in a place where we take action that could be reversed because we didn't have the least legal justification because the facts on the ground had changed. So I know our office, and it sounds like other offices, are taking that very seriously and evaluating many standards that go into that. And it's not, as the situation gets better with vaccinations, and obviously there are other areas that push against that, it becomes a harder calculation with regard to the use of executive authority.
Right. All right. Well, thank you. I appreciate that. So I have another question for the panel. So I understand from my counterparts in consumer finance, servicing, collections, and MSB that the exemptions that were given to the mortgage industry didn't necessarily carry over for all states to all the additional industries. So how are we going to be able to address this disparity between industries when we all end up going back to the office?
For Kansas, we've had those same discussions. Our current guidance extended out to both consumer credit filers and money transmitter entities and things that are also under our purview. Of course, each state is set up differently, so the oversight could be under multiple state agencies. We just happen to be over mortgage, consumer, debt management, and money transmitter in our office. So we took the governor's executive order similar to Mississippi, which is still in effect, as an emergency order, took that authority and then waived the branch licensing requirements for all those entities and put them all under the same in the same date. We've also thought about moving forward how that will be impacted. But because the decision is due to health and concerns there, we're trying to broadly apply it across industries and to not favor one over the other has been kind of our discussion. And again, moving forward, we don't know how it'll end up and how we'll unwind it. But every one of those industries will be given the same amount of advance notice when we go to unwind as much as we can, because again, the governor has issued an emergency order which we do not control in our agency. So we're watching it closely, but our goal will be to unwind that guidance and move back to normalcy in a measured approach over time with notice to the entities.
Great.
I have something. I'm sorry.
Oh, go ahead.
I just want to add that, you know, similar to Kansas, Mississippi issued a open-ended interim guidance for all of our industries, bank, mortgage, and consumer finance. But I will say the conversations now are different based on the industry type, because we're having conversations about resuming some on-site exams, on-site presence for some consumer industries where we're not having that conversation with some of the mortgage industries. And I'll say this, that what appears as a disparity might not necessarily be a disparity, but it may just be a fact difference on the risk of the transactions of that industry type. So, you know, as regulators, we try to assess what potential harm could be to the consumers with a lack of on-site presence for exams versus having one. So I will say that there may be more factors involved than just an obvious difference of going on site, going off site, or an interim guidance applying or not applying to certain industries.
Yeah, I think Maryland is our kind of proposed regulation combined with a previous regulation for MLOs. All 10 of our license categories will be covered with regard to remote work. So I don't think that we have a disparity. So.
And I know in Tennessee, when we issued our original guidance, it was to all non-depository institutions. So that covered everyone. For us in Tennessee, all of the companies you've talked about are regulated under the compliance division. So, you know, we, like Rashonda said, you know, that guidance was issued for everyone, but then now as we're trying to look at different, you know, everybody's their own industry. And so it kind of does play into what's going on, what business is done in this different types of industries and what we need to do to look at them also as a regulator.
Okay, I just want to let everybody know we have
apparent.
about a minute left. So we're going to need to start wrapping up things up on this topic.
So it's apparent, it's very complex. It's encouraging to see that you are all addressing it as seriously as we are in industry. Not all states perhaps have the same dedication or views. I don't know what word to use there, but I think we're all going to come together for the good of industry and our consumers, our borrowers, et cetera, to reunify way to come back. And just as a last thought, perhaps NMLS or CSBS could consider putting an industry working group together like we do for Kiwi and the IDWG, which would represent regulators and industry to get a sampling and get us maybe some guidelines that we can all follow so that we can have a smooth, safe, and compliant transition back to the office. So thank you for the opportunity to address these questions.
And Cindy, I would just highlight that it's imperative for industry to provide information to regulators. You know, you know, the in-office is based on risk, and you know, we evaluated it one way, and other people are evaluating it other ways. To the extent that risk is minimized, or at least there's a place where regulators can feel comfortable with remote work as a long-term solution, you know, it really is beholden on industry to be able to provide a scalable solution that can give comfort to regulators. It shouldn't just be on us. And maybe that's your recommendation for a working group, But I just wanted to highlight that.
Very important, Jed. Thank you. Thank you all,
Yeah,
actually.
thank you. And
I
definitely,
truly-
we have a pattern of talking to each other and bringing each other in the loop. And so transparency is at the utmost of what the states are doing. So through the system, I think we can definitely learn from each other and at least understand the impacts that multiple state decisions are having on the licensees. So thank you again, everybody. And so Cindy, I'll have you sign off, and we will talk to you later.
Absolutely. Thank you so much. Be safe, everyone.
Same to you. All right, our next panel will be joined by Gus Avocados. So Gus, if you'll go ahead and share our audio and video with us. And we're going to be discussing notice of the expiration of the relief from branch office licensing. Gus, can you hear us?
I can hear you, Jim, very clearly. I hear you a lot. First of all, let me say to you, Jim, this was a very good number of panels and the topics that were discussed. So to credit to you for your first chair of the Ombudsman session. If I could say one more thing, Matthews, I am surprised, actually stunned that he's retiring. I thought he had already retired years ago and just showed up at these conferences and walked around. So congratulations to Bill Matthews. Anyway, the topic is related to what Cindy was talking about before, that we're going to exit from this period of relief from branch licensing. And virtually all the states except 2 or 3 did not issue some statement, guidance, directive regarding the relief from branch licensing. Now we're starting coming out of it. Some states had the expiration date as early as March 31st. So I hope that was a poor April Fool's joke, and hoping they extended that date beyond March 31st. I think some have. But the concern we have from clients over here, how far can they go with this relief from branch licensing? What happens after that? Will they have to get the location licensed immediately? How much time do they have to get the location licensed? Every state regulator acted very recently and quickly to extend relief from branch licensing to the COVID-19 period. And the states are modifying the expiration date as we go forward. But again, a few of the states, I think, Jim, you may have mentioned it, and Ms. Kelly may have mentioned that you're going to provide notice to the states of how soon we have to get those locations, licenses, branches. But all the states haven't indicated as much, and we need some comfort. We need some guidance as to whether there will be notice. We don't want the relief from branch licensing to expire, without any word going out to different companies that are relying on it, have been relying on it for years. I hate for them one way to wake up and recognize that they were originating those from an unlicensed location for a period of time because the relief from branch licensing had expired. So I'm looking to you as to what guidance you would think would you put in place for your state and what you think might be appropriate for other states. I have a radical proposal. In dealing with the relief from branch licensing, a lot of states impose conditions on what the companies or best practices of what the companies have to do to continue doing work from that unlicensed location. You couldn't meet with consumers at the home. You couldn't store records or business records there that had to be stored at some other licensed location. So the number of conditions were in place. Why not just issue a branch license for a temporary period of 60 days to those locations that were where the MLO worked from their home and allow the process to catch up by submitting the surety bond or any other requirements to allow the location to be actually licensed as a branch. The MLOs may prefer to continue doing business from their home. Their companies may authorize them to do so, provide more flexibility to those MLOs who are licensed to work from their homes. And if they were already doing so for the past year almost, I think you have a sense that they were doing this in full compliance with other regulations we've put in place. So why not just go forward and issue a branch license, a conditional branch license, until the folks submit the surety bond or other requirements to effectively get that location license? It seems like a reasonable solution, and therefore people aren't going to be under the gun of making sure they stop originating loans before the period of relief from branch licensing expires. So that's my question. Now, one follow-up question to that.
So yeah, let's address that one first. And again, like you said, Rashonda and I kind of answered that, but let's have Nicole and Jed just kind of answer what you guys have thought about exiting the current guidance and the time that it might take to get back to normal.
So, I think we took a different approach as it applies to remote workers. So we haven't deemed, pursuant to the emergency regulation and what will be final, we haven't deemed remote work type work as a licensable action from that location. Instead, relying on the nature of the relationship with an actual licensed location. So that is not disappearing. And with regard to MLOs, we've had in place for several years now a regulation that identified that as long as it doesn't look like a licensable location, MLOs, the business of taking an application is different than what's required under the mortgage lending law for the mortgage lender license. And so they can accept applications and negotiate terms of a loan from a non-licensed location as long as they meet the standards. So,
Okay,
yeah, I think that probably answers your question, Gus.
thank you.
So, somebody else is going to respond before I respond to Jed's point. It's good, but to Jed's point, it's good to hear that that is the case. And from what I'm hearing, you're telling me there's statutory language or regulations that provide as much. And I'm worried about the states that have issued some kind of guidance or temporary guidance, but there's nothing in the statute that allows a licensed MLO to originate loans from an unlicensed location when the state law requires the location to be licensed. So could a consumer, unless something is formally issued by the state, could a consumer bring an action against a company from originating loans from an unlicensed location? That's a concern we have going forward, in addition to how much time they'll get to get that location licensed if they so want it licensed.
Okay, so Nicole, if you want to talk on Tennessee's perspective.
Yes, I can. And for us, we're a little bit, Tennessee's different. Also, I know we've got our interim guidance in place that the MLOs can work from their homes. For us, you have to get a branch authorization in Tennessee to conduct business from a branch. It's not a separate. You don't have a separate license, so to say. And so we've allowed in the past for companies to license people from their home offices, or from their homes. We're different in that regards. Also, Tennessee is definitely different. But due to our interim guidance, we did allow people to go home without getting that special branch authorization. And as far as timeline, our interim guidance was set indefinite. It's until, otherwise notified. And I can tell you from the way that we do business in Tennessee that there would be plenty of a very good time frame and plenty of time before we would expect to have all those people that are working at home licensed as an authorized or registered as an authorized branch with us in the state.
Thank you. So let's move on to, Gus, you made a point about just whether branch licensing should be reformed and whether it's needed moving forward. So past the pandemic, getting into that mindset, let's talk about the pros and cons of that approach and the risks and so forth. So, any panelists that want to speak up, please do.
Well, you're muted, Gus.
There are some states that are considering repealing the branch license requirement. The foremost, it's gone the furthest, is the state of Washington. It has branch licensing right now, but they're pursuing and are championing legislation to repeal the branch licensing obligation. So if people were working without a branch license for months at a time now, meeting all these conditions that were imposed by state regulators to be able to work from home without a licensed location, what would hold you up from just getting rid of the branch license obligation entirely? Maybe imposing additional fees if you're going to do business from more than one location. But people are already doing it. I think they've satisfied, any concerns you may have about doing it legally. Chuck Cross will come after them if they haven't originated the loan in connection with the applicable law.
So Gus, I don't disagree with you. I think that when you marry our emergency regulations that are going to become final with understanding, what we mean today about, where the license, kind of the concept of locations is much different given technology. I think that we're thinking through what that looks like and how we could maybe move to regulating entities and then capturing locations through functionality on the NMLS, depending on how that development process works. But you raise a couple of important points. If I was to get rid of my branch locations today, that would take about a third of my revenue out. And so we just need industry to support us in that process. I think that there's great efficiencies, and this is just me speaking for not for, on behalf of my administration, but there's great efficiencies if we can move away from branch licensing. But we do need support and understanding that there has to be different ways to generate revenue to meet that gap, and then also there needs to be an honest conversation about bonding, because at least in Maryland, several of the bond licenses are tied directly to locations, which is not as maybe the most sophisticated way to do it or the correct public policy way to do it. But those are some of the areas that crop up if we're to reconsider branch licensing, which I don't think is an unreasonable discussion to have.
Thank you, Jeff.
I'll take a stab at the commenting next. So, branch licensing, licensure is a part of licensure for Mississippi. So that's in statute. That's a legislative change. But our statute is a little different than it has requirements for in-state MLOs and out-of-state. So in-state licensed locations must be zoned commercial, and loan originators cannot work from home with those zoning laws. Out-of-state, there is no commercial zoning requirement, so they can work from home. So that's another part to this. But I will say our obligation as a regulatory agency is also consumer protection. So the licensure of those branch locations, it helps us track the activity of some of these LOs. So this is also a factor. Now, while the revenue side is relevant, that's really not Mississippi's driving point. I think it's more on the consumer protection side, just tracking those licenses. But I do think that this is a good conversation to have. We have not looked forward for any substantive permanent changes down the road, but we are discussing what if and why not.
Well, I appreciate that as well, but there have some states that have never licensed branch offices. So should we talk to those regulators, they can tell you they have good or bad experiences. And as I said, Washington is going forward with legislation that they are supporting to get rid of the branch licensing obligation. So it seems to be time is right from the experience you've had from dealing with branches during this COVID-19 period to push for that legislation at the state level. And I understand there may be some zoning considerations unique to Tennessee that maybe put in the legislation initially, but who knows what, if even the legislators still there that kind of back the zoning problem. But nonetheless, it's good to hear that you are all considering this.
Gus, do you think there would be any concern from industry if we said we gave functionality in NMLS, or whether using functionality today through NMLS that would require just at least registering all locations, but not having the same type of branch requirement? So it's less onerous, but at least we can capture the locations where all of the core operations are being done, especially in the context of and in conjunction with Kiwi.
I don't know. I think that's more of a question for Kobe. If there would be some reservation amongst industry, just registering them, or just listing them, as opposed to actually going through some formal process and getting them approved. If I recall, Maryland had the most onerous requirements for branch licensing. You couldn't do business even from a restaurant. At one point in time, before MLOs were licensed, you couldn't do business from a restaurant and dealing with the consumer at the restaurant table and taking their application. So you've come a long way, Jeff.
Yeah, I would talk to your colleague about that one.
No, that's a good conversation. And just to bring in Kansas's viewpoint, we're also looking at the risks, and I think the panelists have made a good point that we need to consider the risks in this day and age with the way business is done now in 2021 is not the way it was done when the branching came into effect. In Kansas's experience was in the 90s when our mortgage laws started to develop and licensing and so forth. So I think it's a good point to bring up, and I think it's a good reflection of we may be able to better mitigate risks knowing what's going on with companies in terms of how work is done, regardless of the way branching turns out. But let's say branching reforms and you have less, because right now there's a little bit of dark in how the IT functions of a company are done. A lot of states don't review IT security risks and things. It's really done by non-regulators, independent agencies or service providers and that sort of thing. So I think some good can come of this in terms of learning more about the industry and the way it's best, the risk is best mitigated through regulation. So. Yeah, good discussion. So thank you all for your discussion on this, and we're going to move on to our next topic. So thank you, Gus. If you would go ahead and click on leave to turn off your audio and video, we'll bring on our next panelist. All right, next we'll hear from Melissa Coppell with Loandepot, speaking on behalf of the Mortgage Banker Association. Melissa, if you'd please join us by turning on your audio and video. Hello, can you hear us okay?
Yeah, can you hear me?
Yes, we can.
Excellent.
Welcome.
Well, thank you. And thank you, Rashenda, Nicole, and Jed for also having me and entertaining my ideas that I'm going to present today on behalf of the MBA. So yes, I work at Loandepot, lead up the licensing team there. I've worked with many of you also attending on the call. So I appreciate the continued partnership. But for the purposes of today, representing the Mortgage Bankers Association, I'm currently the chair of the State Regulatory and Legislative Committee and heading up the task force specifically in regards to the remote work. So I would like to say to Cindy and Gus, they've highlighted a lot of the different aspects that we've been addressing since, can't believe it, but for over a year, right? Since we all went into this situation that we're currently discussing and dealing with. And I think the focus that what we've been able to achieve through the MBA task force, through partnership with the CSBS, NMLS engagement, and of course all the state regulators, is over the last year, I think we'd all agree that we've had some very good conversations on this topic, and we can see some of the results of that coming out of the changes that Jed has done in his state of Maryland, in addition to what we've seen coming out of Washington, in addition to Arkansas. And let's not forget the states that just don't regulate branch locations at all. So they were already, I guess, ahead of the curve for this particular issue, right? But in regards to that, I think in listening to the discussion that we've had up to this point, one thing that jumps out to me is that we could lead into, as states, adopt new legislation, guidance, whatever it may be, depending on the state and what you're held by, is the definition of a remote work from home versus a remote location. I think there's a distinct difference between those two. And just kind of to tail off of what Gus was discussing in regards to all the different locations. I've had several different situations come across where I've got snowbirds, right? Like they're in New York part of the year, the other part of the year, they want to work from their second home in South Carolina. We have things of, yes, we've dealt with a pandemic, but we also know that a lot of our states have dealt with natural disasters. I'm in California, so we all know California is on fire, I think is what everyone thinks, or we're falling into the ocean because of an earthquake. But I know that a lot of the other parts of the country, whether it be snow, rain, whatever it may be, it also forces some of our workforce to work from home from time to time for extended periods. And then most recently, we've had several in which you have, people needing to take care of loved ones that are out of state, but want to be able to continue to serve their customers and to also maintain their jobs. So I know we're at the top of the hour. I guess save me for the end because I talk the fastest. But I think is to really urge that all the states to keep this as a topic and to move forward on what we can solution in regards to the future of our workforce within this industry being able to work from different locations and not be beholden to one location. Even in the idea of one loan officer working several locations within a 10-mile radius. Some states will allow that, other states will not. There's certain limitations that are within the branch licensing scheme, dependent on the state, that it does preclude kind of the industry from being able to expand and move with the rest of the country and kind of how we all work. So I appreciate everyone's engagement up until this point, and I look forward to continued discussions. And please, other industry on the call, regulators, you can reach out, of course, to the MBA. Kobe spoke earlier, or to reach out to me personally. So not sure what else to kind of bring up. I feel like we've already covered it, but I guess I want to be the cheerleader to keep the conversations going.
Thank you, Melissa. Yeah, we have covered the topic pretty extensively. I think what we really need to continue the discussion with is just the risks and concerns of this wholesale change in the branching environment. But realizing that we've had some test cases, right, with other states that have already done it. I think we have a lot to learn from each other about our priorities and where the risk really lies. I know there definitely are some efficiencies to be made in the regulation if there are less branches to run through an approval, denial, process and that sort of thing. But I think we need to figure out where to best put our resources and time in terms of risk that happens from remote work. And with consumer information is paramount with privacy and things of that nature, but also access for the state to determine compliance. And if that access is not at a branch location any longer, where is it? And where are the exams going to occur? Because we do often do examinations at a branch here locally. And you meet people and you do an exam on site, you get the kind of the best of both worlds. You don't have to fly out of state and expend those resources, but you also get, an in-person exam. And maybe something like that continues with a registered location or just knowing where the company is operating and that sort of thing without the branch licensure structure and so forth. But there are definitely things to consider on both sides. The IT risk seems to be something that a lot of people have brought up, and just learning how that's done today. Kansas did start an IT examination program early in 2020. We were fortunate enough to get some examiners that were trained specifically in that area. So we've started to roll that out and learn about the risks and where companies are in that framework, but it's very new for us. And I know other states are in the same boat where they may not have the resources necessarily to do a full-fledged IT audit and examination. So I hope that we can lean on each other in terms of this cooperative supervision to work with each other and help each other out in terms of regulation across state lines for the larger companies that maybe pose a little bit more risk than others. So great conversation. Yeah, Jed, go ahead.
Yeah, Melissa, you raised an interesting point because we handled it in our regulation. You talked about remote work from home versus remote work kind of as a different concept. In our regulation, we evaluated that and provided flexibility for remote work up to 2 weeks a quarter to facilitate business or for personal travel, for example, as long as the company that licensed that individual, the licensed entity authorizes that type of travel or work from a different location. Do you think that that's important? I know that some people thought there was value in that, but is that, like, when you say that, is it focused on just allowing for remote work from home, or do you think a comprehensive resolution also gives some flexibility?
I think that's on the right track for sure, Jed, just because it's just complex, right? When you talk with all of our MLOs, and we're also talking about now some states require last minute agents to be licensed. And then if we also open that up to our processors and underwriters, which in some states also require to be based out of a licensed location. And so from that, I think the dynamics for, like I said, someone in North Carolina, someone that lives in New York half the year and then goes to South Carolina the other half, then we contemplate, okay, so then do I need to license 2 locations, one in South Carolina and then another office in New York in the states that LO is licensed in? And then do I change his MU4 and the relationship based off of him bouncing back and forth, just more or less for the purposes of paperwork, right? Or do I just declare from the beginning that these are the locations that this LO could work for, and this is the home location in South Carolina, North Carolina, or the one up in New York? And so then you as regulators know where that LO is, because that is important, right? To know well, what options are they going into? But do I now, it almost ends up being like an ACN for a branch, okay, so now this LO is moving and I need to give you a heads up, or do I just on the fly? But then now I'm changing relationships all the time. And I think that almost becomes messier for all of you, then helpful. And so I think having that flexibility, whether it's 2 weeks or just the declaration somehow in the NMLS that they do work remote from time to time, or how that balances out, it just it's a good question, Jed. And I think to the idea of the working group, it's good discussion to be had amongst the groups of where we want to go, because I do get concerned that some states will only say work from home, and then they're going to look to that MU4 as the residential address, and that's the work from home location, versus another regulator stating that it's just a remote location and not defining it as home. And now we get still back into the same quandary of the state's not aligning, and now I have to go to the most restrictive, I guess. So,
yeah. And then one other point, thank you, Melissa. And one other point, Jim, I want to point out is, especially as we talk about this, and this includes industry, Melissa, I guess we license a whole different scale and size of entities. And so sometimes the really sophisticated companies are on these work groups, but our policy needs to be scalable. And I don't know if every state's going to be as comfortable as maybe we were. But for example, the decision around whether to force it to be a company issued technology, or it just allowing for anyone to use their home computer if they have a VPN. Some of the positions we got where you have to require it to be company issued, but that really impacted the smaller businesses. And so I think that we really have to be sensitive to the scope of businesses the size and scope of businesses that we regulate across the board. It's not just the biggest, it needs to be scalable as a public policy solution. So
definitely,
yeah,
that's a very good point.
Yeah, and I agree with that, Jed. And I think even on that, I mean, if you have VPN or Citrix, right, and you have dual authentication, if that's what you have to go through to access the LOS, that's not really providing just as much as if I were to issue you a laptop and you still had to do VPN, right? I mean, there's certain levels there. It's not like flip. There's differences, yes, but is it enough to force one over the other? I'm not sure. So I guess IT's needed again, right? They always feel like they're part of the conversation. I guess we'd have to loop them in to give us that. But I know at least with the pandemic, when I walked into the floor of my licensing group and I said, okay, today's the last day, happy St. Patrick's Day, you're all going home, today. We didn't have, company issued laptops for everyone that first day they had to go home, but we couldn't skip a beat. So, if it does get to a natural disaster and requiring it to be company issued, technology, then that could actually end up still kind of holding us back, right? Instead of saying, okay, well, you have to go through this Citrix link to be able to access the LOS.
Yeah, I just raise it because it was a policy solution offered by a different industry group where they said best practices and you should implement. It would have put, in the space that they were, there was a bunch of small players that those small players would not have been able to comply. And so, not to saying it's the best, the best solution might be that way, but to your point, we're trying to evaluate risk, and it's really important, as I said before, for industry to help us evaluate risk and to make decisions so that you as a customer also don't get harmed, and maybe your competitors don't get harmed, because this is like I said, a global solution, not we don't want to create competitive disadvantages that aren't risk sensitive.
No, that's a very good point. There's a lot of players in play, and thank you guys so much for this discussion. I'm sorry that we don't have any more time to discuss it, but we need to move on. And again, I just want to thank you, Melissa, for joining us again, and all the other panelists. And if I can go ahead and have thank you to Nicole, Rashunda, and Jed. I think all four of you, if you can go ahead and just close out and leave the panel. And I appreciate again the discussion, and we'll talk soon. I do have one quick announcement, and again, thank you to all the panelists and all the conversations today. It's been a wonderful exchange of ideas and thoughts and concerns, and we definitely will continue this discussion. I have one quick announcement before we wrap up. CSPS is working to develop the next generation of the NMLS to anticipate and accommodate the evolving needs of the state system of financial regulation. Starting today, on behalf of the NMLS Policy Committee, CSPS is requesting public comments and feedback on the networked licensing model, the licensing requirements framework, core requirements, and identity verification proposals. The full proposal can be found on the proposals for comment page in the news and events section of the NMLS Resource Center. Comments on the proposal will be accepted through May 31st, and they should be sent to the email comments@csbs.org. So again, thank you everybody for the conversation. it was a great one, and thank you for attending today's meeting and engaging in our chat. If you have any other questions, please continue to reach out to the NMLS Ombudsman at ombudsman@nmls.org.